Welcome to Hurt at Work, a Kentucky workers' comp podcast. Today, Louisville workers' compensation attorney Scott Scheynost is going to provide helpful information, tips, and advice for injured workers and their families. Scott's goal is to help you to maximize the benefits you receive. If working's got you hurting, sit back and listen to Scott address topics that matter to you. Welcome back to Hurt at Work, a Kentucky workers' comp podcast. We're in the studio today with Louisville workers' compensation attorney Scott Scheynost. And this is episode 3. We're going to talk about what's my case worth and go over 3 important factors. Scott, welcome back, buddy. Good to see you.
Glad to be here.
Absolutely. So when people ask, I guess that's one of the first questions that after they've done a workplace injury or gotten hurt at work or on the job is, hey, Scott, how much is my case worth? And that's probably a hard one to answer.
It's a very common question when somebody calls in, and if somebody doesn't ask me that, I can tell in the back of their mind they're thinking about it. And I'm happy to discuss that issue with somebody that calls. The biggest problem, though, is a lot of times I don't really know until you've gone through some significant medical treatment. There's a lot of things that we look at in a workers' compensation claim, and some of those facts that determine how much money you're going to get, we don't know when you call right after an injury. A lot of times we have to wait until you've gone through your medical treatment and you've reached this magical point called maximum medical improvement, MMI. That's a common phrase in workers' compensation. Sometimes that happens a week or 2 after the injury. Sometimes it happens literally years after their injury, depending on your medical treatment. But everybody wants to know how much your case is worth. I'm happy to tell them. It just sometimes takes a little bit of while to figure it out because a lot of it depends on how you recover. And until we know your condition, we don't really know what your permanent impairment rating is. We don't really know if you're going to be able to go back to work at your old job. We don't know if you're going to have any problems working in any other job. So until we know all those factors, we don't really know the exact dollar amount of your case. But to start this off and to give you a little bit more insight, we're going to give you a couple of indications on what we look at to figure out what your case is worth.
And as we kind of put this episode together, we said really there's 3 different areas we're going to talk about today. The first is the monetary compensation, the monetary benefits.
That's the biggest thing, right?
Right. And the next is the non-dollar benefits, the non-monetary benefits, which really refers mostly to the medical coverage and getting the medical bills paid.
Right.
Through the system.
People don't realize that you not only in addition to medical benefits, you have a couple of other things in Kentucky. For instance, you might be able to get vocational rehabilitation, which is retrained if you can't do your old job, and right. Another right to reopen your case to get more money if your condition worsens within a significant time period after the injury and after the claim's been resolved.
And that other factor, number 3, would be other actions, such as other lawsuits that may be related to the same injury, such as if you were in a vehicle accident, you may have an automobile accident claim, you may have products liability if you slipped and fell somewhere, and you could also have a Social Security disability claim. And we'll talk about all that as we get to that segment. But let's come back to the money side of it. That's probably the most important.
Yeah, that's what everybody wants to know, right?
Talking about, and I guess the first factor is what you call TTD. Do you want to explain that?
Yeah, we use a lot of acronyms in workers' compensation, and one of the bigger ones is TTD, which stands for temporary total disability. And that refers to the money that somebody gets when they're hurt and they're recovering from the injury, but they haven't completely recovered. And it's the money from the time that they were unable to work until the time they reach maximum medical improvement. That's another acronym we use a whole lot, MMI. So TTD is what usually most people think of as the money they get from workers' comp. You're off work, you can't do the job. Workers' comp owes you some money so you can get through life while you're recovering from this injury. How much money do you get? Well, once you've been off work for a week in Kentucky, you get TTD. You don't get it for the first week unless you've been off work 2 weeks. It's like a 1-week deductible that gets met if you're off more than 2 weeks. And I know that's confusing, but the biggest thing to remember is if you're off 2 weeks, they owe you money for the entire time that you're off work. How much money do you get? In Kentucky, you get 2/3 of your average weekly wage. Well, it sounds simple, but it's a little bit more complicated than that. 2/3, why do you get 2/3? Well, there's no taxes taken out. There's taxes taken out of your wages, and the 1/3 that they don't pay you is supposed to represent the taxes that are normally taken out of your wages. There's no income tax on the TTD that you get, so that's one reason why you get 2/3.
So I don't have to report this on April 15th.
TTD is not income underneath the IRS definitions of income. It is not taxable as income. So that's not something you're going to get a W-2 for, 1099 or anything like that. You're correct. You don't have to report that as income on your income taxes. Again, that's why you get 1/3 less than you normally do. The big problem about TTD is figuring out what your average weekly wage is. and that's another acronym we use, AWW. Your average weekly wage in Kentucky, there's a very complex formula that we use to determine that. And real briefly, what we do is we look at your wages for the 1 year period before the injury. This is for an hourly worker. We look at it different ways for people that are paid piecework, people paid commissions, people paid on a salary. Those are a little bit different, but most people are paid hourly, and we're going to concentrate on that for right now. We look at the wages for the 1 year period prior to injury. That means each week in that 52-week period before the injury, not how much you were making afterwards, but before. In those 52-week periods, we divide that down into 4 quarters. So you got 13 weeks in each quarter. And I know everybody's having fun following me on this.
You're doing great math.
Oh, well, we got Excel spreadsheets now to do all this. And we use them frequently for this. But we break those four quarters down. And why do we break 4 quarters into this? Well, most people have a quarter. For instance, if you're working retail, you work a lot more during the Christmas season. If you're working delivering sodas, you work a lot more probably during the summer. But usually there's a busy period of the year that most people in their job have. And we break this into 4 quarters because you get the best quarter to determine your average weekly wage. And we break it down a little bit more in each quarter in these 13-week periods. We look at how much money you're making per week. That means hourly rate per week, and we multiply that by the number of hours. So if you're making $10 an hour and you're working 50 hours a week, for our purposes, we determine that as $500 a week. You don't get what we call the overtime premium. So we do consider overtime, but we don't consider that extra bonus you get for being on the job and on overtime. And why is all this something I'm talking about right now? I frequently find that people that get some kind of bonus or some kind of overtime don't get that considered in their average weekly wage when the employer or the insurance company do these computations. As you can tell from my description of it, it's a very complex procedure, and it's pretty frequent that the claims adjuster doesn't go through this procedure.
Well, I tell you, something you've mentioned in a previous episode is that it's not just the wages you're earning at that job when you got hurt. If you have a side job, if you have a second job, sometimes a third job, that income also gets added to this computation.
I'm glad you brought that up because that's what we call in the workers' comp business as concurrent employment. And it's basically a second job. So yes, if you have a second job that can be considered in your wages, the criteria there is that your employer, somebody in a supervisory capacity, your foreman, a manager knows that you've got a second job. If they know that you had a second job, and if that second job was also covered by workers' comp, for instance, if you're a real estate agent and there's no workers' comp involved in that second job, that's not something that's covered. But, if you are working in a factory and your second job is down at a fast food place, and that's covered by workers' comp, then those wages also get included in all this.
So it's not a guarantee, but more than likely there's a chance. So you ought to, one, let your attorney know, but you need to let the company know as well.
Right.
Is there a good way that an employee should let their supervisor or their company know, hey, I've got a second job? I mean, would an email or a letter or something?
That doesn't hurt. Most times when you have an employer, you just tell them that. And most supervisors and foremen are going to acknowledge they've been told. Usually they've got to do things to schedule around that, or there's something that's come up during the course of your employment that they know about it. If you're working for an employer that you don't think would ever recognize that, then you may want to do something to document it.
Right.
Have them put something in your personnel file or something like that. It always helps to have a friend here that you told your boss or supervisor or foreman that you had a second job, you had to leave early to go work it. So occasionally that becomes a problem when the employer denies it. But most people have got some kind of a record already where they've had to take off work early. There's something in the personnel file. There's a fellow employee that's heard them talk that way. Unless you just got a notoriously bad employer, that's usually not a big problem. But sometimes you deal with folks like that, and you've got to protect yourself. So the more documentation you have, the better. My experience is most people don't even think about all this stuff when they have the workers' comp claim. Most people don't even know that the second job gets considered, and we usually got to bore down through this and find out exactly what's going on, and we'll deal with some of those issues later on. But all this kind of brings up another issue in workers' comp. There's actually a maximum as far as the money that you can get for what's called TTD, temporary total disability benefits, and that changes every year. And we're doing this in January 2020, and had to go back and look at the numbers to see what the new number is for this year. But the maximum is $979 a week. That's the most you can get for workers' compensation benefits for being off work. For most people, that's not a big deal. But if you're making $3,000 a week, there are some people out there, or maybe you've got a quarter where your average weekly wage is $3,000 a week. If you were making $3,000 a week, then 2/3 of that's $2,000. Well, and unfortunately in workers' comp, you only get $979 a week. Now, my experience with folks that make a lot of money like that is sometimes they have some other source that might help them. For instance, they may have sickness and accident disability benefits. There may be something else floating around that they can use to get additional benefits.
They might have a private policy.
Correct.
Or their company may offer them some other type of additional stackable.
Yeah. Usually I call these folks high wage earners where they max out, and usually there's some other sort of benefit either through themselves where they've gone to their insurance agent and got additional benefits, or the employer itself provides some of these benefits. And usually with a high wage earner, there's another source of income. And we just have to ask them a couple questions about that. That's not really part of workers' comp, but you might be able to get that because you had the injury at work.
Right.
So that's TTD. How long do you get TTD? Well, I've had people get it for 5 or 6 years. You get injured and you're off work, can't return to your job. You have a surgery, that doesn't work out. You have another surgery, you go through recovery, that doesn't work out. I've literally had people get it for probably 4 or 5 years because it's taken that long to recover from the injury. Now, that doesn't happen to everybody. But occasionally, you have folks that just get bad results. They have bad injuries.
It is classified in that situation as TTD, temporary total disability, because the doctor still says, well, there's a possibility of improvement. You haven't hit this MMI, this maximum medical. So as long as it's temporary, that's why this TTD still applies.
Correct.
Even several years down the road.
Yeah, and you may not be able to work after you've reached MMI, but the TTD stops when you reach MMI. And then we look at another kind of income. Once you reach this magical point, maximum medical improvement. And when is maximum medical improvement? That's when you're not going to get any better. You're not going to get any worse. You've reached a state that's going to be basically the same for the rest of your life.
Doctors can't really do anything more.
Pretty much. Or you might be able to get what we call palliative treatment, medicines and stuff that decrease the pain. And you might be able to get braces and stuff like that. And it may even require some injections and other, near surgery type treatments, or even surgery itself sometimes. But it's a magical point. It's hard for me to describe it because there's not a red flag that pops up when you reach it. You're going to walk in your doctor's office one day. He says, you're at MMI. I can't do anything else for you. And your money's going to stop. It's important to have all your eggs in a row before then, because if you don't, you're going to come and see me, and I'm going to say, I don't know much about your problem, and it's going to take us about 6 weeks to figure it out, because I can't do anything until you've come in and we've talked to you. We know what your problem is. We got your medical records. We've got to file a claim. That takes a while to get the documents together. So if you've gone through a significant amount of medical treatment, at some point you're going to reach MMI, and you need to be ready for this. You need to have your ducks in a row. You need to have your stuff ready for that point and figure out what you're going to do once you reach it. But bringing it in what happens after you reach MMI, that's money for what we call permanent disability. And permanent disability, there's two kinds of permanent disability. There's partial disability, where you can do some kind of work, and then there's total disability. I'm going to talk about total disability first because that's a little bit easier to describe. Total disability is when you cannot work any longer in any job. You may have worked on a factory line, and maybe you were a mechanic or a tool and die person, and you're making $45 an hour. You can't do that job anymore, but you can work at Thornton's at the cash register taking change. Even though your wages go down from $30 to $10 an hour, you're not totally disabled because there is a job that you can do. So total disability is not common in workers' compensation. You literally have to be unable to do any job that might be available. That does happen, though. And when that does happen, you basically get the same money you were getting when you're on TTD until you turn 70. That's what the law is now for somebody that was injured after 2018 until they turn 70. Before that, there's some arguments and there's some court cases discussing how long you get benefits, and there's an argument that you might be able to get them for the rest of your life. But after 2018, after July 2018, there's no doubt that your benefits will stop at age 70. So you get that $979 a week if you're maxing out until you reach age 70.
And there's not really a guarantee, though, that you're going to hit that $979. That depends on the average of everything up to that point for the last 12 months.
Right. That's correct. You may have a number that's lower than that. If you're working part-time, it's going to be significantly lower. The other permanent disability we have is called partial disability, and that's the most common. Partial disability is really, I think, a lot what people think about how much is my case worth after we've gone through the medical treatment. That's the one that involves impairment ratings. That involves whether or not you can go back to work. There's actually a formula that we go through. There's 5 factors we look at in the formula. I'm going to bore everybody to death with this real fast, but we get an impairment rating from a doctor. There's a book that tells the doctor how to do that. We determine your average weekly wage. We talked about that earlier. We have to figure out if you can go back to work at your old job, return to work at your old job. If you can't return to work at your old job, your money basically triples. We look at your age. The older you are, usually the more money you're going to get in workers' compensation. And we look at your education. And usually the less education you have, the more money you're going to get. And the reason is it's harder for you to find a job. GEDs count the same as 12th grade education. So the only time education really comes into play is if you don't have a GED and you've got like 11th grade education or less. There's 5 factors: impairment ratings, average weekly wage, return to work, age, and education. Some of those you think are real simple, such as age and education. I've actually had cases where I've argued about all 5 of those factors. I've argued about somebody's age before when they were born. I've argued about their education. And you think, how can you do that? Well, some folks don't grow up in the United States. They're not born here. There's not really a record of their birth. They may only go through 6 years of school, and that's considered high school to them. We don't do that here in the United States. So I've argued about all 5 of those things. And I never thought I would argue about somebody's age, but I have argued about that before. The more common arguments we have are really involving the impairment rating assigned by a doctor and whether or not somebody can return to work. Return to work, the employer always thinks you can return to work. I've got to see an employer that thinks that you can't return to work. That's just their nature. They think that everybody can come back to work. There's a job here that you can do. Of course,
not be the same job.
No, it may not be the same job, and they're not going to treat you the same way sometimes. But every employer argues that they have a job you can do. But frequently, that's something that can't be done. When you can't return to work at your old job, that actually increases the amount of money that you can get in a workers' comp claim. Usually, the biggest thing we argue about, though, is the percentage of impairment, because there's a book that tells the doctors how to do the impairment rating for different types of injuries. For instance, a leg injury. There might be 7 or 8 different methods to determine how a leg injury should be used to determine an impairment rating. For instance, leg length discrepancy. What the heck is that? That's how long your leg is. Sometimes people have injuries and they have medical treatment that actually decreases the length of their leg, and that causes limp. So leg length discrepancy is one way to determine an impairment rating. Whether or not you have to use a cane, a crutch, a wheelchair to walk, that can determine whether or not you have an impairment rating. Specific operative procedures, for instance, if you've torn your ACL and you've had to have that repaired, that's a specific impairment rating. Range of motion, strength, there's the pain. There's a lot of different factors that can be used to determine your impairment rating. There's a lot of different ways to determine impairment rating. And what happens is the doctor's supposed to use the one that's most beneficial for you. But what you find out is that certain doctors do the impairment ratings different than other doctors. Generally, the insurance company or your employer is going to send you to the doctor that's usually going to come up with a lot lower impairment rating than all the other doctors you see.
This is the company doc.
The company doc, yeah. After a while, after you've done this, you realize how doctors do impairment ratings, and the ones that tend to do it on what I might call a more conservative fashion tend to get more referrals from insurance companies and employers because their numbers are lower. And when the impairment rating is lower in that formula we talked about before, you get less money. So that's a big driving factor. This is actually pretty important because a lot of times when your employer says you've got to treat with a company doctor, which is not right in Kentucky, they're really setting you up with one of these doctors that they know will eventually give you a lower impairment rating. They're actually trying to save money on your case and the eventual outcome that's going to come maybe a year, 2, 3 years later by sending you to a certain doctor they know is going to help them out down the road. And I've said this before. I think we were talking about this yesterday with Jim. The doctor you pick is very important in a workers' compensation claim. And in Kentucky, we have a choice of physician where the employer cannot tell you what doctor to treat with. They frequently do, and they frequently tell you the law in Kentucky requires you to go to their doctor. That's not the law. But what they're trying to do is to set you up with somebody they think is going to help them up down the road. So your choice of doctor is a very important thing in this. I can send you to 5 different doctors and get 5 different impairment ratings, and guess which one the employer is going to send you to when you're injured. So there's a formula for this to determine the permanent impairment rating. a formula to determine the permanent disability money. Most of these things, or not most of them, but a couple of these things we really can't determine until you're done with your case. What's your impairment rating? Well, we can't do that until you get done with maximum medical improvement and you've reached the point where the doctors know nothing's going to change. Are you going to be able to go back to work? Well, we don't know that till you've concluded with your medical treatment and the doctors have issued permanent restrictions on your activities. So a lot of these factors we use to determine how much money your case is worth, we don't know until you've completed your medical treatment. Now, in a car accident or maybe a different other type of case, when you go before a judge or a jury, there's somebody that's estimating what these numbers will be. And, you may have 5 years more of medical treatment, but you go before a jury and you have somebody testify this is what's going to happen. We don't do that in workers' compensation. And the reason is you're supposed to be getting money while you're off work recovering from this. So the money is supposed to replace the wages you were earning. You're getting your medical treatment. And from the workers' comp standpoint, theoretically, you're not in bad shape. So we're not going to decide all these factors that determine how much your case is worth for the permanent disability until you've reached this maximum medical improvement. Theoretically, you're getting money for being off work. So that's why that's a little bit different than a car accident. A lot of these car accidents and stuff like that involve a third-party case or something outside of workers' comp, you can get a pretty decent idea of what that's worth once the injury happens.
Right.
There's still things that affect that, but in workers' comp, generally, we got to wait till you're done treating with a doctor, and that can be a week, 2 months, 2 years.
But again, the difference is you're getting paid along the way by
theoretically
by nature of the
theoretically. Yes, that's
yeah.
theoretic, and we fight over getting TTD for folks too,
Yeah.
Because claims can be disputed. They can argue about whether or not you should be on TTD. Yep. There's doctors that will say that you should be off work. There's doctors that will say you should not be off work. Guess which ones the company wants to believe.
Exactly.
So we can argue about all these things.
Well, let's transition now to the second factor in determining the case value or what my case is worth, and that's the non-monetary benefit. These are the medical bills, the medical coverage that comes along as part of your workers' comp coverage.
Right. There's really two big things you get in workers' compensation: money for being off work and for the permanent disability. The other big thing is medical treatment, and we're talking about Kentucky. In Kentucky, you get all reasonable, necessary medical treatment. If you've got to go to the doctor, if you've got to get a prescription, if you need a brace, you get that. That's paid for. If you go to physical therapy and you have to drive there, you get mileage expense for driving back and forth. So all reasonable and necessary medical dispenses are paid. You don't have the right to go to the Mayo Clinic and have an evaluation by a doctor up there. That's probably considered unreasonable. But, here in Kentucky, if you're seeing doctors here and they say you need a medical treatment, assuming that it's not something that's experimental, you're probably going to be able to get it.
Well, and that could mount up. If I live out in the counties, out in the state, and I need to come to Louisville or to Lexington or something like that to see a specialist, I still get coverage for that mileage.
Yeah, and frequently I find that the employers and workers' comp carriers don't tell you about all the benefits you can get, and mileage expense is one of them. I've gotten literally thousands of dollars for folks that were driving from Corydon, Indiana to Louisville for physical therapy. They did that for a couple of years, and nobody ever told them, it's about 50 miles one way, that they could get 41 cents for each mile they drive, and it adds up after a while. Frequently, I think the adjusters know they've got to pay it. They don't tell you about it for a couple of reasons. First of all, that's more money they've got to pay out. But secondly, you're requiring the adjuster to do a little bit of extra work because you're sending in forms to them. They've got to go through, they've got to do the math, make sure you're driving the right place, the right miles. They don't want to mess with it. So if they don't tell you about it, they don't have to deal with it. But frequently, people are not told, and people don't understand they can get mileage expenses. And if you're not going to somebody local, if you're driving from out of town, that can add up real fast.
Absolutely. What happens if I have to overnight? What happens if I've got to go in and maybe incur a hotel?
Well, travel expenses, that includes hotels, that includes meals if you've got to travel for that. It's pretty uncommon for us really to deal with hotels for right. Travel expenses in Kentucky. Most places in Kentucky are within driving distance of a half day, and most of the far ends of the state. I'm here in Louisville, but if you're in Paducah or Pikeville, there's not a big medical center in each one of those that people drive to. Somebody from Pikeville to Louisville, though, they may have to incur overnight mileage expense and hotel fees and even
if you've got an early morning
meals.
Surgery,
yeah, I can see where that would have to be paid.
Yeah.
And I think we've done that before too. But if you're doing it because of work, if you're doing this because of the work-related injury, and you're incurring expense because of it, there's a real good chance they have to reimburse you for that. Okay, there's a couple other things besides medical expenses too. Before I change subjects, in Kentucky, we get lifetime medical expenses. That means that after your case is over, after you reach maximum medical improvement, if you got to go back to see the doctor, if you have to have another operation, if you have to have a brace replaced, if you have an eye problem, you have to wear glasses and they get broken, the employer is still responsible for that medical treatment. They don't usually tell you that. Sometimes you have to do some things to preserve that. But in Kentucky, you get lifetime medical benefits. Other states like Indiana, I think they stop once you reach maximum medical improvement. But in Kentucky, you can have lifetime medical benefits. The employer still has the right to argue about whether or not you're entitled to them. They can dispute them, which brings up another thing about reopening your case to argue about whether or not you need medical treatment. But you get lifetime medical benefits in Kentucky. A couple other things you have in Kentucky, and I don't think this applies to Indiana either, is you have a right to reopen your case. Once you've got your case settled, once you've gotten a decision from a judge, you've got like a 4-year window to reopen your case if your condition significantly worsens. That means if you have an impairment rating, it gets worse. Generally, surgery is going to cause that, or just something happens to make it worse. If it significantly worsens, especially if your impairment rating conditions, you can reopen your case. You can get more money for being off work in the form of TTD while you're recovering from surgery. You can get more money for the permanent impairment rating that we were discussing earlier. It gets complicated about how all this is figured out. You probably need an attorney to do all this stuff. The big thing about reopening is you don't get any money until you reopen. If you're going to have a surgery from a prior workers' comp injury, and you want to get money for being off work because of that, and you want to get money because the impairment rating might increase, you need to see an attorney before you're off work and before you have the surgery. If you don't do that before you are off work, you may lose the right to get money for being off work. If you don't do this before you have the surgery, that might cause problems in how much money you get for that too. So if you think you're going to reopen your case, you probably need to see somebody as soon as possible to see what you have to do that. And the thing about right to reopen, first of all, other states don't have that. In Kentucky, there's like this 4-year window. And again, it starts from the date you either settle your case or get a decision from a judge. You've got 4 years from that point to reopen it. One more thing we have in Kentucky is vocational rehabilitation. Vocational rehabilitation is not commonly awarded by the judges in the system. It's something I'm talking about because it's available. It's a right to be retrained for another job. A judge has to think you're a good candidate for it. So it's not something once you get an impairment rating you get. The judge has to think that you're a good candidate to be retrained. How do you do that? Well, usually you have to be a little bit younger than me. Young pups that are still willing to go to school. I know everything. I can't go back to school. It doesn't do any sense to send me back to school. So the older you get, I found out, the more we seem to know. But the younger you are, generally, the better your chances of getting vocational rehabilitation. For instance, I've had judges tell me before they would never award it to anybody over 45 years old. I have had judges that awarded to people that were over 45 years old, though. But in general, the younger you are, you're better the chances of getting it. What else is your ability to go to school? If you've gone to school before and you've done well in school, you've gotten good grades, you've completed high school, maybe you've taken a little bit of college. If you've shown an inclination to go back to school to be able to learn, the judges is probably a little bit more inclined to do that. There's not many people that are 50 years old that are going back to school. So if you're in that age, 18 to 30, you've got a good chance of getting vocational rehabilitation. But there's another requirement, and that's that you cannot do any job you've ever had before. So if you can't do the job at McDonald's, if you can't do the job, that you were doing earlier when you were in high school, all those factors are things the judge looks at. My experience is that if the judge thinks that you're a good candidate, they really want to help you, though, and you've got a good chance of getting that. In Kentucky, you're supposed to get 52 weeks worth of vocational rehabilitation. That's 1 year. There aren't a whole lot of 52-week programs out there. Most colleges 4 years. You might be able to find a trade school program. I've had folks that wanted to become gunsmiths. I've had folks that wanted to, go back to beauty school. There are some things available for you there, but once you get that, the employer pays for all the vocational rehabilitation benefits that you need. They pay for the tuition, they pay for the books, they pay for the labs. You might be able to get mileage to go back and forth to school. You might be able to get meals and stuff like that if you're going to a dorm and staying overnight. There's a lot of things that you can get in voc rehab if you're a good candidate. So if you're younger and you have a significant injury that keeps you from doing your job, you might be a good candidate for it. It's not really something that comes up a whole lot in workers' comp because it's not really rewarded a whole lot. I talk about it because I think a lot of other folks forget about it. Sometimes I have to remind the insurance company that that's available for you. If you're younger and you can't go back to work at your old job, you probably need to talk to somebody about that because that might be a significant benefit for you.
Absolutely. And then the third factor that we want to talk about today in considering what the case is worth, the fact that you may have other legal actions available to you. I mean, it's quite possible that you could have other, quote, lawsuits or claims that you could file at the same time as you're pursuing your workers' comp benefits.
Right. And frequently I'll see somebody that has a really significant injury, especially if they're a little bit older, close to my age. They may also have a very good claim for Social Security Disability Insurance, SSDI. SSDI is something that's a government benefit available if you've been able to work and you've had money paid into the system and you qualify for it. And I think we're probably going to have somebody else talk about that a little bit later on, Trevor Smith.
Yeah, we're going to bring Louisville attorney Trevor Smith with Smith & Wax. He'll be on a future episode. He's located right here in Louisville and focuses almost entirely on Social Security Disability and SSI.
Right. And generally, I'm going to refer people that might have that kind of case to Trevor because he does it, and I don't normally do a whole lot of it. But I think the big thing to look at there is your ability to work. If you're not able to work in any job, you probably have an SSDI claim. And Trevor will know this a little bit better than me, but the older you are, probably the better chances of winning that claim. And you may have an SSDI claim for total disability, even if you don't have a claim for total disability because of the workers' comp claim. They look at slightly different criteria. In Social Security, I understand they'll look at all your medical conditions. For instance, if you hurt your foot and you have an ankle problem, that's what we're going to look at in workers' comp. But, you may have a heart condition, you may have high blood pressure, you may have other things that we're not going to look at in a workers' comp claim that might be able to get you Social Security Disability Insurance. And Trevor will talk about that a little bit more. I think the big thing to remember there is if you're having problems working, then you may have an SSDI case and you need to talk to somebody else about that. And then I guess the other things we're going to talk about in case there's a motor vehicle accident.
Yeah, I mean, for instance, if you were traveling for work or maybe your job requires you to be on the road for work and you get in an automobile accident, you obviously were working at the time, so you've got a potential workers' comp claim. But you also may have just a normal automobile accident claim. And I know you were a guest host on a podcast actually yesterday with local attorney Jim Desmond of the Kentucky Auto Accident Podcast. That episode will be published here soon, and that's you can find that at attorneydesmond.com.
Right, especially if you're a truck driver. If you get hit by somebody else, if you're driving a truck for a company, guess what? You got a workers' comp claim. But if you're hit by a third party, somebody that's not an employee, hopefully it wasn't in your employee parking lot, you've got a potential third-party action for that motor vehicle accident. We talked about that yesterday with Jim. We'll probably talk about that a little bit more. But that's something else that you want to look at. There's other benefits available to you. You've got the lawsuit against the third party. You also have what are called PIP, personal injury protection benefits in Kentucky. We're a no-fault state that might be available. Workers' comp's primary, which means workers' comp pays for all the medical treatment and you being off work. But in certain situations, you might be able to get some other benefits pretty easily, especially if you're one of these high wage earners we talked about, because there's maximums in the amount of money you get per week from workers' comp. You may be able to get some other benefits from the no-fault insurance carrier PIP benefits, what we call.
And so potentially this could be a sales rep who's just going from appointment to appointment. This could be maybe a secretary or an assistant needs to run an errand for the boss or the supervisor.
I've had executives going to board meetings in different places too where that's occurred. And that's one of our jobs as an attorney to see what might be out there to pay for your benefits, pay for your damages. People I found out don't realize. I've had 2-3 people in the last 6 or 8 weeks that didn't realize they would qualify for Social Security Disability Insurance. Maybe one person didn't realize they might also have a motor vehicle accident case that might have some other benefits here too. So if you talk to an attorney, that's one of our jobs is to find out what else is available. If it's something that we don't do, we'll generally help you get to somebody that does it. But we do this all the time. We like to talk to people on the phone. It doesn't hurt to give us a call, and we'll try to help you out with this stuff if we can. I think the other thing too that comes up in a workers' comp setting, there might be what we call a products liability action.
Yep.
And if I've had some significant product liability cases too that involve workers' comp injuries. You're at work and something blows up, something doesn't work the way it's supposed to. Well, if you're at work and the weed eater blows up, which we've had that case before, you're at work, that's a workers' comp claim. you may have a lawsuit against the people that made the weed eater.
Well, you're working with some machinery on the line or
Right.
in a press or something like that.
Right.
And something fails.
Right.
There's a chance. There's another option there.
There's a guard missing. Something
Yep.
happened. There's all kinds of things that can come in play here. Again, it's a good idea to have an attorney look at that. Probably the best thing to remember about that is there's different statute of limitations for these actions. For instance, in workers' comp, we've got a 2-year statute of limitations that can be extended if you get money for being off work.
And again, just to clarify, a statute of limitation is really, that's the time from the date of injury to a certain period out in the future that you have to really kind of bring that claim. If you miss that window, you really can't make the claim.
Right. For a workers' compensation claim, that statute of limitation is 2 years from the date of the injury, but it can be extended if you get that temporary total disability benefits we talked about earlier. It gets extended to 2 years from the last date that you got it. Now, in other actions, for instance, the products liability case in Kentucky, there's only 1 year, which doesn't sound like, it's too short, but you take 6 months recovering, trying to figure out what's going on. You've got 3 months to file a lawsuit. Well, we got to figure out if it's a good lawsuit or not before we file it,
Yep.
or we can get in trouble. 1 year is not very long. Kentucky has a very, very short statute of limitations for products liability actions.
In car accidents, roughly 2 years.
2 years from the date of the accident, but that can also get extended if you have those PIP benefits we were talking about earlier. If they pay for medical expenses or money for being off work, they can get that extended.
Of course, with any of this, it's better to notify not only your supervisor, but to notify an attorney early so that documentation and that case can really start being substantiated in terms of the injuries, the expenses you're incurring, and things like that, to get some of the benefits rolling your way.
Right. And just to make this a little bit more complicated too, in some of these situations, there's different statute of limitations for different states that can apply. For instance, if you're in a truck and you have an accident in Missouri, while you're working for somebody, well, that's probably a Kentucky workers' comp claim if you're based here in Kentucky. And we've got all these statute of limitations I was talking about for Kentucky workers' comp. For the motor vehicle accident, though, you probably got a Missouri statute of limitations, which might be longer. And in the products liability stuff we were talking about before, you've only got 1 year to do something in Kentucky. But if that product was made in Missouri, they may have a 5-year statute of limitations. You might be able to file a lawsuit in Missouri because if it was made there, you might be able to bring suit against them there. And again, this boils down to talking to somebody that knows what's going on. Just because it's been 1 year since this happened doesn't mean it's shut out. There may be a good reason it is shut out, but have somebody look at this. The bigger the case, the more important all this stuff is to figure out.
So don't rely on what your aunt told you. Don't rely on Judge Judy. Get a hold of a qualified attorney.
That's true.
Absolutely. Scott, you've got a fantastic website. You've built a lot of content on that website over the years. And friends, if you'd like to check that out, you can go to www.scheynost.com. That's SCHEYNOST law.com. Scott Scheynost is the attorney. Scott, what's your office phone number?
502-937-5287.
And if you're so inclined, Scott also has a pretty active Facebook page for the firm. So feel free to like and follow him on Facebook as well. Hey, Scott, that's pretty much a wrap for episode 3 here. I really want to thank you for your time. I know you're busy. We talk about your schedule all the time, but I appreciate you making time for this and helping people understand, some of the factors that come into play when they're trying to understand what their case is worth. And it's a lot more than just the money, just the weekly benefits, the monthly benefits. It's all the other options and benefits that come along with it. So once again, Scott, I really appreciate your time. Wish you the best, and we'll talk to you again here in 2 weeks for episode 4.
Looking forward to it. Thank you.
Yep. See ya. Bye. Thanks for listening to this episode of Hurt at Work. Scott will be back in 2 weeks with a new episode. For more information, be sure to visit ScheynostLaw.com. That's SCHEYNOST law.com. You can also follow Scott's Workers' Comp office on Facebook. Until next time, be safe and remember, Scott's ready to help, especially when you and your family need it the most.